Good morning. Welcome back. You're watching Daybreak on Citizen Television. Thank you for staying with us. With me in studio, John Ohaga, Senior Counsel on my far right, Professor Joel Ngugi, the Court of Appeal judge here in the country, and Njeri Kariuki, who is a chartered arbitrator here in the country. Senior Counsel, I was on you, and I'm looking at a dispatch from Cabinet on the 23rd of March, and some of the itemized issue is the policy framework of alternative dispute resolution mechanism. And you are in the team, I understand, that was set to the drafting of that policy in regards to alternative dispute resolution mechanism. What does it entail for the Kenyan public to understand that?
Well, let's first of all say, yes, I did chair that committee. It was a team put together by the Attorney General back then. I believe that was during the tenure of Professor Githu Muigai. And now, the thing is that the policy seeks to understand the different needs of the different sectors of essentially the economy. And so what we did was to split our economy into different sectors. What does the insurance industry need? What does the banking community need? What do the construction industry need? What does the legal system itself, the lawyers, require? And what we then did was to gather views and to understand their different needs and how those needs can be addressed through alternative dispute resolution. And so the policy addresses all those different needs and then establishes or comes to the conclusion that what is required is to establish statutory frameworks that enable all these different players to find pathways and doorways through which they can resolve their different disputes. And so, for instance, it's not limited to arbitration or mediation. There is conciliation, for instance. There is adjudication, for instance. And overall, we needed to find a framework in which we could create a coherent alternative dispute resolution framework, rather than having discordant voices speaking different languages at different times, and package them and bring them together so that the users would appreciate that if you have a certain kind of dispute, perhaps the best framework for you lies in conciliation, or lies in adjudication, or lies in mediation. And that way, you then have legislation that is the foundation for you being able to find the way in which you want to resolve your dispute.
In terms of the diversification, I mean, how does it work then in regards to commercial matters, succession matters, matrimonial matters? Because many Kenyans want an understanding of the scope within which, or the framework within which these conversations do take place in terms of settling these matters alternatively after pulling the matter out of the courts of law, the court of law.
In fact, I always say we shouldn't be speaking about alternative, we should be speaking about appropriate. So when we talk about ADR, we're talking about appropriate dispute resolution. So what is appropriate for your particular dispute? If you're in a succession matter, involves your family, perhaps mediation is where you should be going, because that's really gives you the best tools for the resolution of that dispute. If you are you mentioned commercial matters. It depends on the nature of the commercial matter. We just had a banking mediation summit last week in which we were talking about how mediation is appropriate for dealing with a large majority of banking disputes, because most banking disputes are between borrower and bank. The bank wants its money, the borrower has some constraints, but the bank is perhaps able to give some indulgence. That's a matter for discussion rather than a matter for adjudication. So what is the most appropriate for the nature of dispute that you have? Some disputes are just ego-driven. You need to understand that this dispute is really about a clash of egos. And then as lawyers, we create a complex case that has its foundation in just egos. And then we bring it before the judge. And we plead it, you know, we present voluminous documents, we plead various Latin terms, but really at the core of it is just an ego fight. We need to be able to appreciate what the foundation of each dispute is and what is appropriate for the resolution of that dispute.
Okay, well, I'll come to the professor about that. And what happened before the partitioning and the scramble for the African continent, and what was there before for the African culture to sort out some issues under a tree, and which were very binding and even led to stability amongst the communities. In Njeri, there is a specific concern here, and talk to me about the access to, as the Senior Council calls it, appropriate dispute resolution mechanism outside Nairobi, in terms of the literacy is what I'm looking at, accessibility, the logistics, understanding where will the third party come from, especially for the far-flung counties, including in Mandera, in Busia, in Lamu, and in Kakamega County.
Well, just going back to what you just said about sitting under the trees, please recollect that this is something that is already within our psyche. So I know part of when this whole journey started to introduce mediation and AGS and just about everything into the court systems, that was part of what people looked back on the Njuri Ncheke and what was within the traditional systems that could be made use of. But getting back to the actual mediation pathway, that the journey that we have made, we started with a pilot project in Nairobi, okay? And then it became part of the justice system. After it worked so well and the cases started moving and so on and so forth, then it was introduced into the court system. So having started with the nucleus of Nairobi, with plenty and building up of mediators, the ones that are required by the court systems, it has slowly gone out into the counties, into the court systems within the counties. And mediators, there are plenty of people to train mediators today, and they've all spread out throughout the country. So mediators are aplenty, even within the court system, the mediation court system. So it is not to say that people are going to be left out. They're not going to be left out. It is spreading throughout the country. And in fact, the reach is great already. Maybe has just not been popularized in terms of the numbers, but mediators are available, at least within the court annexed system. And the sensitization, I know there's so many outfits, NGOs, so on and so forth, that are actually have gone out into the various countries to sensitize people about how positive the results are of mediation and the other ADRs. So it is not only a Nairobi thing. Far-flung counties, they're receiving the same kind of attention.
Prof, here is now another, may I say, a steep slope. The consensus between the Senior Council, you and Njeri here, is that this is a process that is addressing many challenges, including taking the burden off the shoulders of the judiciary. But there are less than accredited 1,000 arbitrators, may I say, or the third parties in this case, in the judicial website. And the many cases that many people, the many instances, and a large number of Kenyans who are opting for that system of justice. I mean, the ratio seems to be very few compared to the number of cases that are coming before these arbitrators. I mean, where is the balance here?
Okay. So thank you for that question. So I think there are about 1,500 accredited mediators throughout Kenya. So that's a good number. But it's important to say those are the ones that are accredited by the Mediation Accreditation Committee, which means they can participate in the court annex mediation. But as I was saying, a court annex mediation is not the only form of mediation. So those are the ones that are accredited by the judiciary. So the judiciary can send cases to them. But there are a lot more mediators in this country than those 1,500. There are very, very many people who are, first of all, trained in mediation. But even moving beyond mediation, mediation is a specific method of dispute resolution where the third party, the person who will do the mediator, goes through a training so that they facilitate the negotiations between the parties in a specific scientific way, okay? But there are many people in this country who do what I call the organic African way of mediation every day, every single day, in Mandera, in Wajir, in Busia, in Kakamega, and so forth. And when that happens is what we call alternative justice systems. This is things that have been done since time immemorial, okay? And those ones don't need the imprimatur of anybody. They don't need the license of everybody to resolve those cases. And in fact, when we did a survey, we found that the majority of cases in Kenya are decided by those guys. When people have a dispute in Busia, in their community, most of the time, they will organically know who to go to, which mzee is able to resolve their dispute, and they'll go to them, and most of the time they will go and they will sit and they will call their witnesses, and that means they might call 2 others, and they will sit and they will decide that case. And what we are saying is that that's okay, and it is allowed by the Constitution. It's in fact encouraged by the Constitution, and the Constitution says you don't need anybody's permission. You don't need the judiciary's permission to decide that. You don't need the senior counsel's permission to decide. You don't need jury's permission to do that. And certainly you don't need my permission to do that. And we're encouraging people to continue doing that in as long as they are keeping with the constitutional minimums. Exactly. Now, the constitutional minimums are given in Article 159(3) of the Constitution. And it says, in the first place, whichever form of alternative dispute resolution that you use, and especially when using a traditional system, you must make sure that you adhere to the Bill of Rights. That's a minimum. Right. Any procedure or any substantive outcome that is outside the Bill of Rights, our very progressive Bill of Rights, then that is not allowable, and that will be null and void. Then it talks about, it talks in the language of any outcome or any procedure that is repugnant to justice and morality, but understood contextually in terms of our contextual democracy. Then that will also be deemed to be impermissible and inappropriate. So in as long as you keep yourself within those confines, then you can decide those cases. And in fact, we find that that is how most cases are decided in this country. And what we want to tell people is to continue doing so, and that the narrative that they only get justice when somewhat they bring that outcome to a font of a justice dispensing mechanism in the form of a judge or a magistrate is really a colonial notion. And we are telling them they unraveled themselves from that colonial notion in their 2010 constitution, which they bequeathed to themselves. Okay,
but Senior Counsel, then here is another, the flip side of the coin. In the event a party is not contented with the outcome of that mediation process, of course, in the context of the courts of law, you can appeal that decision until to the apex court in the country. Then what happens? Is there an appeal mechanism in the alternative or the appropriate dispute resolution mechanism in the event a party feels continuously aggrieved and that matter isn't settled by the third party?
Well, the thing is that you have to appreciate that when you go to mediation, there is no compulsion to settle in mediation. You don't have to agree. If you're dissatisfied with the potential outcome, you walk away. And that's the beauty of it. You walk away, but that doesn't mean that it's a spring door to some abyss. It means you can go back to court. Now, when you go to arbitration, as you recognized, is quasi-judicial. If you're unhappy with the outcome of it, again, you can go back to court. Now, what it does, though, is to set out very narrow parameters within which you can go back to court. Because the policy of the law is you chose to go to arbitration. You understood what the tenets of arbitration were. If you were dissatisfied, then as a court, we will only entertain you on some very narrow grounds which are set out in law. When you go to conciliation, conciliation by its very nature and the term of it is to reconcile. That means it's in your hands. So the whole purpose of this is really to put the tool in your own hands. And you don't have to be thinking or worrying about resort to appeal or resort to some other framework through which you can challenge any of these mechanisms. And really what we're talking about here is moving a large majority of our disputes from this formal framework. And the thing about the court system you have to appreciate is the law says how many judges we can have in this country, how many judges of appeal we can have, how many judges of the Supreme Court we can have. There's no law that says we can only have X number of mediators. So that means mediation is scalable. There is no law that says we can only have 2,000 arbitrators. So that is scalable. So as demand rises, the number of resources also rise to meet that demand.
Yeah.
So in that sense, it becomes a system of justice that really essentially frees the judiciary to deal only with those cases, the most complex cases that they need to apply their minds to, they need to apply the law to, and be able to resolve in a way which the law recognizes.
And Prof, as I posed this to you as a law professor, and I looked at the trend in terms of the uptake in Asia, New Zealand, and in Australia, where there seems to be an upsurge in the number of alternative dispute resolution mechanism, people opting for that out of the court, the longevity of the cases in courts of law. And from the intellectual perspective then, is this perhaps with our constitution or context now in the Kenyan context, is this perhaps the shedding off of the colonial mentality which rather had scrap-hipped the African context of solving their own disputes, the traditional way of doing that, which came rather with the colonization, the scramble and partition for the African continent, and up to an extent until we promulgated this law, have been in the dark, and therefore the need for rediscovery?
No doubt about that. Thank you. There's no doubt about that. I think we're coming into our own. The Constitution of Kenya 2010 is progressive and decisive in that sense. What it does, for a long time, we received an independence constitution, which basically contained what I call a virus, a modernist virus, which sort of infused everything within it, that told us everything modern was good, everything traditional was bad, and therefore our aim as a nation was to sanitize ourselves through this very difficult process of modernization, and then we'll become a nation through modernization. I think the 2010 Constitution sort of decolonizes that discourse and tells us that no, our aim as a country is not to be, you know, a mini United Kingdom or a mini Scotland. Our aim as a nation is to become organically a Kenyan country. So some of that which we always did as traditional is rational and good and progressive, and we must keep doing it. And that is why we retained, you know, Article 11, a very progressive article that tells us that as a Kenya, we pride ourselves in our diversity, we pride ourselves in our culture, and we believe that we are building a culture that is Kenyan. From our many diversities, we will keep those Kenyan diverse cultures, but we'll also build a culture that is Kenyan. And then we also retained our right to culture in Article 44 of the Constitution. So what we see in the Constitution of Kenya 2010 is a move by Kenyans to say, we will no longer consider that which was traditional as irrational. We will consider it as rational in as long as it fits within the confines. So in that way, we are really decolonizing the African justice systems. We are saying maybe we shouldn't have given up our African justice systems just because we were told they are bad and they are backward and so forth. We need to go back and mine the gems that we can find in that system, and we keep that which is good, while as we organically grow as a nation.
And Jerry, talk to me about then the training level here of stakeholders, including, for example, the chiefs and the police officers on the alternative justice system. How much knowledge have they been impacted with, if need be, and the facilitation of the process for that matter in the delivery of justice?
Actually, that I would not know. But
okay, yes, then Prof can take that up. No problem.
I think that's something more.
Yes, I thought you were being very unfair to Njeri.
That's more his line.
Yes, that is my question. Yes, so I do chair the National Steering Committee for the Alternative Justice Systems in the judiciary. So you'd recall that the duty bearer for promoting alternative justice is the judiciary in our constitution. And I believe that was very intentional and advertent. Yeah. And that is why the judiciary, as a result, formed a task force that came up with the AJS policy, and then now a steering committee, which I'm privileged to chair. And our aim is, that's why I gave the date of 2028 as the final date, because our aim is by 2028, every Kenyan must know about the alternative justice system, and every duty bearer and stakeholder who needs to be trained on alternative justice systems and alternative dispute resolution would have been trained by then. So we've started the process. We've started training judges and magistrates so that they know where the systems intersect with each other. We've started training prosecutors. We've started training OCSs. We've started training chiefs. We've started training practitioners, AJS, elders, and so forth. But we're using the court users committees as the nodal points for these sensitizations and trainings and so forth. And our aim is that in 5 years we would have done everybody that needs to have been trained. So as a result, let me just say that my committee is multisectoral. Everybody in the justice system is represented in the committee. So we have a representative from the National Police Service as well. We have a representatives from the national administration, what we used to call provincial administration. That's Ministry of Interior. We have someone from probation, courts, everybody that really should be in the justice system is represented in my committee so that we can take basically a panoramic view of who we need to train and what knowledge we need to impart, who do we need to sensitize, and so forth.
Okay. Jerry, then herein comes the... you had a point? Please,
no. Okay.
Herein comes why AJS and how, for example, it's unlocking cases that have taken time in courts of law. For example, I'm looking at the communication aspect. What people say accounts for about 7% of the communication process. And the tone of the voice and feeling what that person needs contributes about 37%. 56% is the body language. I mean, then talk to me about how, for example, your body language may not account for if you appear before Professor Joel Ngogi in court of law because you'll be sitting there to hear the litigation process. 37%, your tone will not be heard because your advocate is speaking for you. Yet there's only 7% of what you can say outside the court, and then you can't delve into the nitty-gritty details of the court matter because of the process which is already before a judge or a court of law in the country. Is this perhaps why we are seeing an influx of cases to AJS, because someone can express himself, you can understand his body language, and even makes it easier for the mediator to come to a conclusion which is mutually beneficial? It's not about who wins or who loses, but all winning.
That's right. In fact, I like the way you've scientifically got all those degrees, 37%, so on and so forth. Yes, body language is very important in terms of communicating the way you feel about what you have received from the other person who you are sitting face to face with, trying to resolve the problem before you. So yes, you will communicate how you feel, what you feel, so on and so forth, through what you say, your choice of language, your choice of words, your, as you say, your body language, so on and so forth. All those things are very important in terms of mediation, where mediation is concerned, perhaps even conciliation. The ADRs, you know, we're talking about ADR, we're talking about AJS here, we're talking about arbitration. But within the mechanisms where we are trying to resolve, get a win-win solution, it's important to communicate both through words and through the way your body conveys how you feel. That is what then will assist you as one of the parties to divest yourself of whatever it is that has caused this problem to arise. So you will get an opportunity to speak and say, I feel, I say, I so on and so forth, this is what this person did to me. Ultimately, you will have all the fury, the angst, everything that has caused you to be unable to bring a resolution to this particular problem. You'll get rid of it through that process. And that's why, as you say, there's that influx into ADR mechanisms, making use of ADR mechanisms, because you get a chance to say what it is that has caused this problem to arise. And you also get to produce to generate the solutions that will allow a win-win solution to come about.
Is there a feeling of male domination in that process, in terms of the mediators, the arbitrators?
No.
Gender is very important. It's constitutional.
No. I don't know if that plays a part with it, but you get to choose your mediator. If you want a male, you want a female. But the point is, does that person have the skills to allow you to communicate with the other person and get your win-win solution ultimately? That's all that matters.
Okay. Senior, yes.
Let me just add, you know, the reality and what we have found, even through the formulation of the policy, is that when parties go to court, number one, your pathway to the court is through a lawyer. And once you come to the lawyer, you become captive to the lawyer.
That's true.
The lawyer formulates your case, the lawyer reframes your facts, and the lawyer introduces your prayers to the court. And we found many times that when parties go to court, they don't actually know what they're asking for. Eventually, when the judge says, "What do you want?" what they say they want is at variance with what the lawyer actually framed.
Okay.
Yeah? So what Njeri says is very important, and what the question you raised is very important, because those appropriate dispute resolution methods allow the parties themselves to be able to articulate their issues, to be able to find their solutions, and to be able to find outcomes that meet their needs, which may not necessarily align with outcomes that the law defines as the proper outcome for a dispute such as yours.
Can I just add something? Because I think it's very important that Kenyans understand this. When you have a problem with your neighbor or a business partner and so forth, and you go to a lawyer, I want to demonstrate to them what happens. When you go and you're speaking with a lawyer, usually the lawyer, you're speaking and the lawyer starts thinking, is this a contract problem? You're describing your problems, your issues, and they're thinking, is this contract? No. Then you reach a place and they're thinking, oh, no, it's a tort. And then you're thinking, and then, no, maybe it's a constitutional issue, right? And then they're thinking, no, maybe it's an issue of statutory interpretation. They are trying to think in terms of legal categories, which then will be presented in a plate. They're not really thinking in terms of the nuances of your issues and so forth. Maybe all you want is, Njeri really messed me up, and I want her to say sorry to me. And if she said sorry to me, maybe I will leave it aside. We don't have a language or categories as lawyers for really comprehending that and putting it in a legal document. We only know what we were taught in law school. We were taught about torts, we were taught about breach of contract, we were taught about constitutional issues, we were taught about failure of administrative action, and so forth. So every time you come to us, we will try and comprehend your issue in terms of the legal category. We call them pigeonholes. So that we can present it to court in that particular way. And that might not be what you want as a justice seeker. But that is what we know, that's what we were taught, and the lawyer is trained to communicate with me as a judge. So that if you bring to me a plaint that says all Njeri wants is an apology, I'm just going to tell you,
to understand that
I don't have jurisdiction to issue apologies except in defamation cases. So maybe you're in the wrong forum. So the lawyer will be forced to try and reduce it in a legal category that is comprehensible to the judge or to the magistrate. And then a lot of what you want as a justice seeker is really lost in that translation. So it's a real problem of incommensurability there.
Okay. Senior counsel, still on you then. Professor talked about the institutional framework and what needs to be done in terms of the changes. Talk to me about the challenges, because in any transition, and this being a supplementary to our justice system, what are some of the standing out challenges that come with AJS or ADR?
I'm a lawyer, I'm a senior counsel, I'm an arbitrator. The first challenge is the lawyers.
Yeah, always.
Because you have to understand that as lawyers, we are now living from the ecosystem. What we see as the justice ecosystem. Now, when you begin to open pathways to different methodologies of resolving disputes, you're really dissipating that what we see as our bucket. You're knocking holes in our bucket. And so it seems to me that first and foremost, that is something that we've had to overcome. That also means that we've had to train lawyers to begin to appreciate that actually there is another methodology, another justice system outside of court. Mm-hmm. Then there is, of course, users are also a challenge, because users themselves have the concept that they need their dispute resolved by a magistrate or a judge, you know, somebody that they see as trained in law. And so they also need to be educated. They need to have that colonial mentality that the judge talked about removed from their psyche, so that they appreciate that you can go to a third party outside the formal court system and actually be able to resolve your dispute. You can go to a private mediator, you can go to AJS, you can go to an arbitrator, and that is okay. Then there is, of course, the you know, every conflict happens at every point where you have a relationship. Absolutely. Because conflict arises from relationships. And those relationships arise in different contexts. The relationship might be with your neighbor, the relationship might be with your banker, it might be with your contractor if you're building, it might be, you know, wherever the relationship is. So the question has to be, the person that you're in conflict with, are you on the same page in terms of where you can go in order to be able to receive justice? So essentially, and this whole forum that we're in today is actually a very useful one, because it is about education. It is about educating the users that there are different systems of justice available. Once I'm on the same page with the person I'm in dispute with about where we should go to resolve our dispute, that's half the problem solved. But if I go to court and the other party wants to go to mediation, then there's another dispute other than the one that brought us to court. So all these are, and there are a myriad of other challenges that we can outline here, but those are the primary ones that I see.
Okay. Njeri, as I come to you on this as an arbitrator, because I'm looking at some of the problems that normally dot our Kenyan ecosystem. Is corruption or bias a threat to alternative justice system?
Let me put it this way. In terms of mediation, not at all. Simply because where mediation is concerned, we're not making any decisions. The decisions remain with the parties. I've just told you shortly before that the parties are the ones that generate the solutions. The purpose of the third party neutral, the mediator, the conciliator, wherever it is to help the parties communicate with a view to getting them to make a decision on their future. Within arbitration, possibly, and that's where the issue of integrity must be at the foremost of the arbitrator's mind, because the whole process of arbitration requires you as the arbitrator to remain objective at all times, and receiving money from one party or the other one means that your integrity is compromised. So therefore, how do you then render an objective decision which is imposed on those parties? If you have been asked, can you swing it in my direction? So yes, corruption within arbitration is a great possibility, and it can do great damage. So as I said, integrity, personal integrity, respecting the integrity of the process, so on and so forth, is of paramount importance. Yes.
And Prof talked about 1,500 mediators, and the door open, or the open door policy of having many more.
Yes, indeed.
No accreditation or framework needed for that matter. But then, and you said corruption and compromise is a possibility. And to the many others, aside from the 1,500 who are accredited or mediators, does then that come with the problem, the credibility problem that already exists?
I repeat, with mediation, corruption is not an issue. Simply because the decision making is not within the hands of the mediator. The mediator does not make any decision. So no, corruption within mediation, no. And the court annexed mediation process, no. The thing I would like to say, however, is that, once you're tainted with a brush of corruption, that's the end of your career. So why invest in yourself to such a point, and then you end up being thrown into falling into a ditch because of corruption? Okay, but I repeat, mediation, court-annexed mediation, corruption is not an issue. In the arbitration process, it could be, but then that is up to the particular person. I've talked about integrity. You must respect in your own integrity, your personal integrity. You must uphold this, and you must respect the integrity of the process. Because if you're corrupt, then what happens to the process of arbitration?
Okay. Yes, Prof, you had a point?
No. I just probably just to supplement that point, I think we need to understand that the more a process looks like the court, the more likely corruption will be a problem. Because when you are the decision maker, then there is a possibility you could corrupt the decision maker, right? So,
that's true.
So in fact, if we are going to worry about corruption, it is the courts we should worry most about, because it's in the courts where you go, you make your arguments, and then someone goes and sits and makes a decision. That is where you have the risk of corruption at its highest, right? Then arbitration, because it's more court-like, you're also likely to have a problem because, again, there's a decision maker. Someone makes that decision. But the problem is somewhat mitigated by the fact that that's a private judge. I am a public judge, so the fact that there are concerns about corruption and so forth might not so much affect how many cases come to me. But as an arbitrator, you would be worried that any reputation of corruption will affect your business as an arbitrator. So the more court-like it is, the more problem of corruption you would have, and the more you head towards the directions of mediation, the less it will be a problem, because mediators don't make any decision. They facilitate the conversation, the negotiations, and then the parties come up with their own solutions.
But let me also just add that with mediation, don't get the impression that it's a free-for-all as well. I sit on the Mediation Accreditation Committee, and we accredit, our role is to accredit mediators. So mediators must have a minimum training, they must have some experience, and they must also adhere to a code of conduct, which they sign up to. And then they must renew their accreditation every year. So that means, therefore, that we're holding them to a minimum standard of conduct. So as Njeri correctly says, they don't make the decision. So there is no, the risk of corruption is really minimized. But when you move to a more formal system, then yes, that might creep in. And now it comes down to a question of personal integrity, but also the integrity of the parties. Never just think that corruption is with the decision maker. Corruption resides firstly with the parties who come to you. And it depends on the question whether you are amenable to it or not. And then it becomes a question of personal integrity.
Okay. And could there be a problem that might arise from the familiarity of the actors?
In what sense?
In the sense of those who are engaged in the process. If the mediator, for example, is known to both the parties.
That's an interesting question. I'm an arbitrator, for instance. And I've had very interesting situations where I've been in court in the morning before Prof, as a judge, against my opponent. And my opponent is before me in the afternoon as in my role as an arbitrator. So that familiarity may be one that, yes, could bring about a risk of subverting justice, but it also means that my opponent, who has selected me as an arbitrator, knows something about me that he has chosen to engage, which is hopefully the integrity that I bring to the system. So familiarity is good, I think, because when you choose somebody that you know, then you choose the elements of that person that you know, rather than exposure to somebody totally alien to you, who you have no idea what his value system is. So that would be the way that I would look at it.
Okay, and Prof, I come to you on this because it's important we talk about constitutional independence because the Kenyan democracy is anchored upon the pillar of Katiba 2010, which came with an array of independent institutions. And in your speech, after you were named the in your award, acceptance speech, Jurist of the Year, 9th December 2022, and in a lengthy speech, you said some of the issues that drove you away from the comfort of William Gates Hall at the University of Washington School of Law in the United States of America as a tenured associate professor of law to come home and be a high court judge include the Constitution, which triggers in you native optimism for Kenya, protection of few from the many politically, protection of many from the few economically, and protection of the weak from the powerful structurally. 13 years after the promulgation of Katiba 2010, what's your account of how progressive this Constitution is and how far we have come?
Oh, well, that's a doctoral thesis. But let me say I still remain very optimistic about this Constitution. My native optimism that I described in that speech still remains. I believe this is still one of the most progressive but also transformative constitutions anywhere in the world. We knew when we bequeathed it to ourselves as Kenyans that we were going to have challenges in operationalizing it, because this is a constitution, as has been described by other people, it's a constitution that ordinary Kenyans gave to themselves against the wishes of the elites. If it was up to the elites, we would not have the constitution that we have. Unfortunately, for it to be fully operationalized, it means that we have to battle against the political and economic elites who have never wanted the Constitution. So there was no illusion that it was going to be easy. We always knew it was going to be difficult, and the struggle continues. I would say, as Justice Kennedy said of the United States Constitution more than 200 years later, that the work of liberty is never done. The work of liberty continues today in all the different aspects of the Constitution, but I do believe that it is the best tool that we have as Kenyans to achieve the shared prosperity that that Constitution promises.
And that political problem, Prof, seems not to have gone away. And you detailed then in 1990 at Alliance High School you are concerned about the quest for multi-party democracy in Kenya, and at some point the picture of Paul Mwite, who you admired as a student at Alliance High School, then when you read a copy of the Daily Nation as to how political pluralism was needed in Kenya. And in 2017, after the Supreme Court nullified the presidential election, becoming the fourth country after Ukraine, the Maldives, on Australia, the then president said, we shall in 60 days that the will of people show you cannot be overturned by one or two individuals, in reference to Judge Maraga's determination and the Supreme Court by extension. After we return from the repeat poll, he said, we shall revisit your issues. We cannot be working only for you to frustrate us with injunctions. What do you think? Who do you think elected you? There has been a question about judiciary exercises power as who? What are the clarifications before I come to the budget cuts and the operationalization of its funding?
So, so this is an ambush. I must say, we've moved from alternative decisions. So my two colleagues are really enjoying me being on the hot spot. But let me say this: this debate, it's a valid debate. It's an important debate. Let me say it's a valid debate to have. There are always questions about what is described as juristocracy. Do we have a juristocracy in Kenya where judges are the ones who are making all the important decisions and so forth? But it's important to say that the constitution that Kenyans gave themselves in 2010 is a unique constitution. It's different than the constitution of many other countries. It places the judiciary at in a very central role in decision making, and the powers and authority that the judiciary exercises in this country is all defined in the constitution. And Kenyans were very specific and conscious of the authority they wanted to give to the judiciary, because they were acutely aware of the political failures that had happened in this country before. They were also acutely aware of the failures in the judiciary. So what they did, first of all, was to provide a framework, a very thorough and robust framework for sanitizing the judiciary, and then after so sanitizing it, giving it that authority, and then giving them the prime directives. That is why we have what 159 of the Constitution, giving the very prime directives about how it must exercise that authority. So it is something that Kenyans understood, and they understood some of the political pitfalls that we've had in the past and where we are trying to head as a country. And that's why they placed the judiciary in where they did. But it's a valid debate to continue having as Kenyans about what kind of country do we have, how do we continue shaping our polity and our political union. Yeah. Because constitutions are promulgated every day. They're promulgated every day through our interpretation. They're promulgated every day through the struggles that we feed and in animating it. And every day we come up with new meanings to our constitution. So that's how really constitutions come to life.
Okay, I'll come to the self-defensive mechanism that the Katiba 2010 came with. Njeri, I'll come to you. Senior Counsel, because we are talking about the encroachment or creeping into the independence of the Constitution, and the responsibility lies upon the shoulders of every Kenyan to protect its independence for our prosperity. The judiciary's budget had previously been increasing progressively from 3 billion in 2009-10 to 7.5 in 2011-12 before reaching a high of 16 billion in 2015-16. As other sectors continue to receive increasing budget allocation, the judiciary's projected budget in 2017 of 31 billion was slashed to 17 billion. That was in the aftermath of the ruling by the Maraga court after the elections on the 1st of September 2017. I mean, as a senior counsel, as a practitioner of law, are you concerned that there is a crop of political establishment players who have no regard whatsoever for the independence of Katiba 2010? And how will that defensive mechanism be triggered in the event that number increases of people who are dissatisfied with Katiba 2010?
Yes, certainly. I mean, as a senior counsel, as a lawyer, as a Kenyan, I am concerned. I certainly have to be concerned because at the end of the day, the judiciary is, as Professor Ngugi says, is at the center of the implementation of the Constitution. And therefore, the independence of the judiciary is critically important to the propulsion of that Constitution, to the achievement, the attainment of the objectives of that Constitution. Now, if the independence of the judiciary is eroded, and eroded through tools such as funding, and, you know, funding in the beginning lies in the hands of the executive. If the executive uses the funding mechanism as one to undermine the judiciary, one to erode the independence of the judiciary, that then effectively means that what the executive is doing is essentially undermining the propulsion, as I said, of Kenyans' desire for the attainment of the objectives set out in the Constitution holistically. So yes, you know, the direct answer to your question is I am concerned. I should be concerned. And one of the things that we have seen now being attained is the establishment of the Judiciary Fund. Yeah. And so that begins to imbue us with some confidence that we can begin to claw back some of the gains that we thought we had made through our judiciary and which were undermined by the statements such as what you have read out. So as the Judiciary Fund is funded progressively, hopefully the judiciary will get to a point where its funding is sufficient to ensure that it is insulated from the influence that comes with underfunding, the influence that comes with the dependence on the executive and the legislature, actually, for funding.
And Prof argues otherwise, that the Constitution came with, or it's self-equipped with defensive mechanisms in terms of just needs interpretation and people with integrity to put it into the path. Njeri, then I want to understand, as we conclude because of time, and sample the feedback from our viewers. Some might be questionable, and you will be, of course, responding to that. But Njeri, even as a chartered arbitrator, what's your take on our independence, the independence of the judiciary, the practice they are in, and what needs to be done to further deepen our democracy through the independence of institutions?
Wow, that's quite a loaded question. I would say, first of all, that we as people have to, we have to respect the institutions, they respect their independence, and this business of always seeking to to convert or to subvert justice. And I think it's an issue of egos. Doesn't it boil down to something that people have to respect the institutions that stand, that are there to ensure that chaos doesn't result out of we doing what we want. Okay? There are rules, there are regulations, there are institutions. Can we not take a step back as the people of Kenya and say they are there to safeguard our independence and the society within which we live, and take up these rules, regulations, respect for institutions, and walk with so that our democracy can be, we can ultimately respect it. Because otherwise, if we do not respect these rules, these regulations, these institutions in which we live, then we'll have a chaotic society.
Okay, for which our democracy must be dependent. And the concern that ever grows, Prof, across the world of the encroachment into independence of state institutions in the country. Winnie, do we have the feedback? Yes, so let's sample what you are saying on the hashtag Daybreak. The SMS code is 22422 at Citizen TV Kenya and at Ayub Abdikadir. Honorable Lillian Sioi says the COVID-19 pandemic created unprecedented backlog in our courts. Alternative dispute resolution, the solution is a useful avenue of addressing delays, giving speedy justice to the common man. Godi Barasawere says both houses of the National Parliament, in conjunction with county assemblies, should work hand in hand with the legal justice system to come up with a framework that will solidify the ADR and the AJS, what he means, for the sake of harmonious living. Namai Gen 1 says ADR is flexible, less costly, and offers an opportunity for faster dispute resolution. Notably, the larger society is still unaware of such processes. There needs to be more community sensitization, especially in informal areas. Remy Bhutia says to resolve all disputes through litigation is untenable, particularly as it may unnecessarily burden the formal legal system. Alternative justice system is a useful avenue of responding to backlog of court cases. Kenta Daniel says, how do we ensure both rich and poor enjoy justice in equal measure, noting a lot of influence and obstruction of justice in Kenya? And we have Rosie Keane says, at the Kenya judiciary, mediation does not support violence against women and children and not men. Men go through violence too. Isn't that gender discrimination of justice? Okelo Mwalimu says the major drawback to alternative justice resolution is the fact that the rich normally like an upper hand in negotiation, have an upper hand in negotiations, and are likely to exploit the poor, especially where they, the rich, are the offenders. Before encouraging AJR, judges must consider the sensitivity of the cases. Babu Michelle K says the judicial system in Kenya simply favors the rich. If you go to our remand allocations now, you'll get to 8% are the poor people. Corruption in our court systems is at its highest, but no one is talking about it that much. Well, Jerry, one question for you in terms of the rich having the poor hand, and then...
Yeah, well, that can be a concern. But you see, if you have a skilled third-party neutral, they are able to balance these things during the course of the mediation. That's number one. Number two, if there is that imbalance, then maybe mediation, or just as John has been saying, is it the most appropriate mechanism for you to make use of? So if it is not, and there's a possibility of he with the money bags is going to exploit or overwhelm the rights of the other person or the position, then because as Mr. Moneybags thinks that because I have money, I can get my own way, then maybe again, this mechanism is not the most appropriate to resolve that particular conflict, okay, that dispute. So that's, one of the things that John has, said over and over is that, is this mechanism the most appropriate for this particular dispute? So you choose according to your dispute. Yes, appropriately. So maybe that one where there's Mr. Moneybags, maybe that one is the best one to go before Judge Ngugi here, who will then be able to use a very big hammer to ensure that this rich person doesn't get his or her way.
Yeah.
Yes. So let's go by the appropriate resolution of disputes.
Okay. Prof, there was also a question on corruption in the judiciary. We recently saw a judge of the High Court, Said Juma Chitembwe, and the advocacy of constitutionalism and the rule of law is a responsibility upon every Kenyan who must protect that constitution. But then again, the dispenser of that justice, the judiciary, has its own fair share of problems in terms of corruption. How can that be addressed?
What's the question? How can that
be addressed?
Well, I believe the system is working as it should be. There is an elaborate system in the Constitution for dealing with corruption in the judiciary, and I believe it's functioning. I think the JSC has the primary responsibility for ensuring not only there's no corruption, but also the independence of the judiciary. And in the case of Justice Chitembwe, I think it worked the way it's supposed to. He is pursuing it through the avenues that are available in the Constitution. So I think that's the best that we can have. I think
the provided for mechanisms.
Yeah, the provided for mechanisms, and I think I think it's probably unrealistic to hope that we will ever have a justice system where there are no corruption cases reported. Yeah. They will always be there. The question is whether there are credible mechanisms for dealing with corruption when those cases are detected. Okay. And I think that's the best we can do.
Senior Counsel, your final word?
Yeah, certainly. I mean, corruption is a societal problem. Every society has some element of corruption. Judges live within our society. I mean, recently we've seen all the hullabaloo about the Supreme Court Justice, Clarence Thomas. That's a perfect example. In such a developed judicial system, such a developed country, we still have that issue. And corruption manifests itself in different ways. And so I think, as Professor Ngugi has said, we must rely on the systems and the structures created in order to address those issues. And we must trust those systems. And so that really, for me, is the answer to your question.
And for a developed democracy like the United States, where the professor lectured, there was a settlement out of court by Fox News and Dominion of defamation lawsuit of $1.6 billion, but they agreed that Fox will pay the aggrieved party $787 billion over the 2020 elections, and literally buying the false claims by Donald Trump, who was a threat to the American democracy for the period he was the president. Prof, thank you for your time.
Thank you.
The Court of Appeal Judge, Professor Joel Ngugi, was with us in studio. So was John Ohaga, who is a senior counsel, and Njeri Kariuki, who is a chartered arbitrator, for their time here and the educative program we have had here on the broadcast, and your contributions as well, which we thank, and your company since 6 a.m. when you did join us here for the broadcast. Till tomorrow morning, by the grace of God, on the State of the Nation. We'll see you then. Willis is up next. Good morning.